orders which shall include measures aimed at cessation of the continuing violation of human rights and freedom. To order immediate cessation of violations. And here, Your Worship, if you may add on another prayer. It's under that provision that Your Worship, that in this court is brought with powers to order for the immediate cessation. Your clause jurisdiction to order for the immediate release of Dr. Kizza. The other prayer, Your Worship, we are making for the regards to violations under Article 22, the last one now, Your Worship, under Article 22, protection of right to life. No person shall be deprived of life intentionally, except in execution of a sentence passed in a fair trial by a court of competent jurisdiction in respect of criminal proceedings under the laws of Uganda. They are threats to the life of their accused. Threats to life. The circumstances under which he is being detained pose a serious threat to his life. The horrible treatment he is subjected to. But even a statement issued by the army, the CDF himself is on record issuing threats that Dr. Besigye shall only leave Luzira in a coffin. He's on record saying that. That is General Mukaaku. That Besigye shall only leave Luzira in a coffin. That's a very serious one. So this court is enjoined to protect the life of the accused and all of his other rights. Of course, the other threats that will be subjected to file his court in June and whatnot, but we wanted to single out the one relating to his imprisonment now, that will only leave Luzira in a coffin. So we pray that, Your Worship, and the other prayer, the last one we are making the prayer, Your Worship, is in subsection 2 of section 9. That is paragraph 5 and 6. That court can issue criminal and other judicial or administrative sanctions against the persons liable for the violations criminal and other judicial or administrative sanctions against the persons liable for the violations. To start with these ones. These ones, Your Worship. All these security officers in charge of this custody, starting with the Commissioner of Prison, should be sanctioned. Mr. Yabashaija Johnson. He should be sanctioned. Your Worship, the Director of Public Prosecution is equally liable in this, together with the Attorney General. They are equally liable in this. They should be subjected to criminal sanctions for violating Dr. Kizza's rights. We do so pray. We do so pray, Your Worship. Just a quick one, Your Worship, if I may be permitted, we believe, Your Worship. I left out one prayer in 6 because I had highlighted it, Your Worship, to guarantee non-repetition, that court amongst the orders that can be issued, guarantees of non-repetition. So court is again enjoined to make some safety measures and provide mechanisms to ensure that there is no repetition of violations. In other words, they should not be allowed to go back on the Dr. Kizza Besigye. They shouldn't be allowed to take him back to the city, because that would be again violation of these provisions. We do so for your worship.
Now, it should be very clear that A1 is on A in this case for this honorable court. And that the cause of his remand does not arise from his proceedings. Therefore, all allegations and submissions by my land colleague that his incarceration and remand is a violation of his rights. All these submissions are not the concern of this honorable court. They are not. Here are the sections referred to by my land colleague first to where in any proceedings. That means the violations mentioned here, the violations should arise from the proceedings for a given court. The violations suggested by my land colleague should have arisen from these proceedings, which is not the fact. An accused person cannot be in court, faces other violations, then he uses them to stay proceedings in a totally different tribe. That's a fallacy. So this honorable court can stay this proceedings or make any order. Unless my land colleague had wrote a separate application, because the remand of A1 his incarceration in Besigye has no connection with this case in court. Therefore, applications cannot arise from this case and prayers made for his immediate release when this matter is already on bail. It is clear that from the proceedings before this court, there is no human rights violation against anyone. Not at all. He is on bail. That should be very clear. Therefore, the submissions by my land colleagues that this court should issue orders for his release are untenable. Have no part at all. And you know, all case law under the Human Rights Enforcement Act where parties have been successful, the violations have been arising from the given cases. Either they allege torture from police, but that torture should be as a consequence of their incarceration. It cannot be totally different case where you're on bail and you meet a person on the road, they stone you, then you come and say your rights have been violated. So this case should stay. It's unheard of, you know. So therefore, my land colleague should have filed an application. It's totally different application for physical social. It has no bearing on this case. Two, I will still move on to the fact that physical solution is unlawful and was released from jail by the now defunct court martial. This is not true. The judgment of the Supreme Court was very clear that the trials will be transparent. The judgment didn't state that the trials are stopped and people should be released. That is a fallacy. There is no such judgment. So he's in prison legally until the case files are transferred to the civil court. And the Supreme Court gave 14 days. We are still in the 14 days. So, even if court agree with my land colleague that, okay, the violations that, if any, that are being occurred to him arise from this case, and this court has jurisdiction to handle this violation, there is not any such violation. There is no ruling or judgment by any court that trials of civilians in the general court martial, that people have been tried in the general court martial should be released from prison, and that their incarceration is unlawful. It is not there. The questions of you should either seek bail from a court with competent jurisdiction or seek other orders, but not through this court, using this case. Have submitted that the reason for his incarceration are not a concern of this honorable court. This court should not even look into the issue of his incarceration in Kizza. He is on bail. The issue should be handled by those who incarcerated, who remanded him, or if they make any application, which is independent of this case. They cannot mix his incarceration and this case. They are totally different matters. So I don't want even due to that I don't want to go into whether they are violations, whether his rights are being violated. Being in prison is legal, and there is no ruling that is illegally in prison. You cannot be in prison and celebrate Valentine, as my land call it one. It won't happen. There are inconveniences of life. Or have total. So, I would sum up that, this court has no jurisdiction to make orders arising out of its incarceration. That is in as far as these orders arise from this criminal matter. They should have made a separate application to this honorable court. Police incarceration has no bearing on the case before this court. 2, Your Honor, if I am wrong and this court has the jurisdiction, it is not illegal in custody. He is in a lawful custody. And the Supreme Court judgment is clear, he is in a lawful custody. So, Your Honor, I would pray that the prayers by my land colleague that Attorney General DPP be remanded that the prison. No, Your Honor, what they are doing is lawful. So there is no illegality that has been made. So, Your Honor, we pray that this honorable court dismisses the application. And Your Honor allows us, Your Honor, we had made the first and allows us, this honorable court should allow us to present our last witness today, Your Honor. And we have all this time been chastised by my land colleagues for not presenting. When we present a witness now, my land colleague doesn't even want to hear about the witness at all. So,
just give me a minute. I'm getting an IT malfunction here. Yes, Counsel, you may proceed.
There are 2 points that the state is making. And I'll start with the last one. That A1 is lawful custom. Essentially what the state is saying is that A1 should not be complaining because it is lawfully incarcerated. Your Honor, the Supreme Court judgment did not say that A1 and other persons in this category should remain in custody. So we are at a point where the warrant that remanded him expired. About 2 weeks ago. The court which issued that warrant was told not to sit again. This is the first court that he has appeared in for the period for which he has been in illegal detention. Worship, my land friend Mr. Mukaaku asked the state to produce the document under which he is incarcerated, or even the prison document. The state started around that issue, because in reality there is none. So you might be in the category of people who used to be called lodgers many years ago. They are in the prison system under no authority of any office, any court order. Your Worship, the state has not even addressed any of the instances that my land is cited in Article 23. Just ignored them as if they don't exist. So we submit that the unlawfulness of the custody of A1 is clear. And we invite the court to act in the manner provided in section 9 to grant A1 the necessary remedies. On the question of jurisdiction, it is our submission that the court has the necessary jurisdiction. It's in black and white, the text that land claim went, section 7, subsection 2. And 5, 1. It's not an error that this jurisdiction was given to the court. Provisions do not speak of any proceedings and then say in a violation of those proceedings. So our interpretation, Your Honor, is that both section 5 and section 7 apply to this situation. This first court that the accused has appeared in is the one where he's raising the
human rights violations that he has been facing for the last 2 weeks at least. Therefore, we must reiterate our prayer that the court exercises the jurisdiction it has to stay these proceedings, to order cessation of the continued unlawful detention of A1, to order the authorities to cease any repetition of that unlawful detention, and the other prayers that I can pray. Worship should be travesty for the court being aware of the violation. Tell those violating to continue. Or to tell the one who is complaining that I can't hear you, I have no remedy for you. You go back and continue to suffer. That's what will happen if the court were to find. So we very humbly pray that the court grants the remedies they are seeking. Certainly, again on a light moment, it would be an amazing gift on a day like today for that type of order to be so privileged.
Some brief addition, submissions, Your Worship, on the question of jurisdiction. Speak on the question of jurisdiction. Your Worship, the nexus between disapplication, enforcement of rights, and the trial before you. We will go so much on that point. Try to point that actually these are different matters altogether, not at all related. Your Worship, in addition to the submissions made by Bangladesh and Kizza here, it's our strong position that would be a parochial interpretation of Section 5 of the Human Rights Enforcement Act. It would be a very narrow interpretation. Emphasis, Your Worship, should be put on the spirit of direct obligation, where Parliament, in their wisdom, says in subsection 2 of Section 5, the application may be made in any language, orally, in writing, or in any other form, meaning that actually a person can even walk into your chambers even without any pending matter. Any person whose rights have been violated can simply walk into your chambers if by any chance they find you there and say, Your Worship, my rights have been violated. Orally there, in a language we understand. That's how informal the proceedings relating to enforcement of rights are. So we needed not even have this matter pending before you. Even if there was none, we will still walk into your chambers under this particular provision. Orally. That is one way of the submission, that you really do not even relate the matter to the proceedings before you. But on the flip side, Your Worship, even if we are by any state of imagination to go by their argument that you needed to correlate the proceedings before you and these matters, still, Your Worship, he misdirected himself on this. Your Worship, let's go back to the genesis of today's proceedings. On Tuesday, we objected to this honorable court issuing a production warrant against Dr. Kizza and said, you granted him bail. They applied for a production warrant and said, this honorable court cannot issue a production warrant to a person who is on bail. That's what gave rise to the proceedings of today. Because why would somebody admitted to bail, who is supposed to come from their home, be subjected to a production warrant? So they are here to explain why a production warrant should be issued against the prison's authorities to bring back somebody who is on bail. That is the nexus. And two, Your Worship, this honorable court has got an obligation to interrogate issues relating from the freedoms and rights of a person they granted bail. There are conditions that were attached to bail. That he should comply to the orders and appears and when directed by court. But now he cannot, unless brought by the prison's authorities. He cannot of his own comply to the conditions of bail of this honorable court. If you directed that he should come back on man, can he bring himself? Because those are the conditions of the bail. Are they going to be valid? That now he will now be brought by prison's authorities, not himself coming. How about the sureties now? They are sureties who were bonded by this honorable court to ensure that as and when this honorable court wants him, they should cause his appearance. They have now capacity to go and break the prison and bring him. So that means the orders given by this honorable court are rendered nugatory. The orders relating to bail, they are rendered nugatory. And this honorable court cannot sit and watch these orders being violated with impunity. They become illusory. That you admit somebody to bail, and then under serious circumstances is restrained, and the court does not interrogate that matter. So this court has that jurisdiction, actually the mandate to interrogate those issues. So that is the nexus we can draw between the two matters. But our strongest point is that we don't even need to go there. The mere fact that one has appeared before court and there is a written or violation of rights is enough. In our opinion, right now, Kizza has been turned into a safe house as far as the liberties of debtors are concerned. That is the lodging. And that notion has always been there. Your Worship, the people they call lodgers within prisons premises. He is a lodger in Kizza, which is now just being considered as a safe house for him, without any payment charges. Finally, the issue of 14 days of the enforcement. I don't know where my land is. That the Supreme Court said that they are given 14 days within which to keep all these suspects in custody. It is reading too much into the judgment of the Supreme Court. I invite my young friend to read it if he had it.
The submissions of both the defense and prosecution have been heard. The court takes cognizance of the fact that human rights violations, once brought to the attention of the court, must be dealt with expeditiously. However, several provisions of the law, authorities, and scenarios have been placed before the court by both the defense and prosecution, in reply as well as rejoinder. The court owes it to itself a duty to carefully internalize and draw the provisions of the law and violations cited into perspective before a decision on the prayers can be made by both defense and prosecution to be arrived to. The matter is going to be given an adjournment for a ruling on a date. Council, I have the 28th of February. If it's available to you.
Today is 14.
Can you work with the 20th of February? Next week is the 20th. It's within next week, 20th of February. Thursday, the 20th of February. If it's available to you.
Anything next week is available to us.
This one is next week, I think. 20th February is next week, Thursday. Just to allow me time to also internalize all the submissions you bombarded me with. The prosecution has made submissions. I also avail myself a chance to look at the authorities and the provisions of the law. Then we can reconvene for a decision. And so there might be no point in me giving you a date when the court will not be able to entertain a sitting. But Thursday is very open and Friday the 21st. All within next week. Is it available to you?
Is there anything given to us for this matter you want? The students we have it disposed of because we are not about rights.
So the matter will be adjourned to Thursday the 20th of February for ruling. Accused is on bail in this particular matter and his bail shall extend until then. However, the court is not blind to what is happening and that is being produced by prison authorities. So by this adjournment, I'm also ordering prison. If on such a date is still in your custody, produce him in court.
We hope they will not treat this as a remand order, Your Worship.
I do not think they need a remand warrant. They are here with the gentleman. Will you need that? And they've had the date, the 20th of February.
Because it's on bail. But they may misconstrue.
Prisons never disobeys orders of court, especially when they are present. It has never happened, at least not in all my years of service. So I don't imagine that they will not produce him unless doctor himself opts not to appear.
No, our word was for them to misconstrue this as an order of remand.
No. I have clearly stated in this particular matter, Dr. Kizza Besigye is on bail. His bail is extended till that date. However, I am not blind that he's incarcerated somewhere in a different matter. So I'm ordering the people who are here that in the event nothing has changed and is still with them, they produce him on that date. It is as simple as that at 10 a.m. With that said, Council, I have other matters ongoing. Members of the fourth estate, if you could vacate my court so we can proceed with other hearings. Sebit Albert Agostino.
Gracias.